MS such and such learned counsel for the appellant has prayed for listing the matter after 2 weeks. Stop. How do you need list after 2 weeks for hearing?
Oblige.
Yes.
Daily list for motion, item 1.
May I please, Your Lordship?
Yes.
This is contempt
Contempt.
petition.
Where is the order of the High Court?
The page 15 to 53, my lord. And the operative part is at page 50, 51.
50.
Para 8 to, or para 8, my lord. 50, 51, and 52.
You have submitted your applications?
Yes, my lord, the collector has also reassessed the amount of
Okay.
compensation,
Okay.
and the same has also been approved. But the respondent, Union of India, particularly respondent number 1 to 3, have not paid their reassessed amount.
Respondent number 1, 2, 3.
My application is at page 54,
54.
and the district collector concerned has complied with the judgment of this honorable court, which is at Annexure 3 and 4, my lord.
Okay. This is a contempt petition under Rule 9 of the Contempt of Court Rules 1997, read with Section 11, Contempt of Court, Guwahati High Court, within bracket, Rules 1997, read with Section 11 and 12 of the Contempt of Courts Act 1971, for non-implementation of this court's order dated 21/11/2024, passed in WPC 126 of 2021. Stop. Heard learned counsel for the petitioner, Mr. Such and such. Stop. It is submitted by the learned counsel that the petitioner has already submitted his applications for reassessment of compensation as directed by this court, vide letter dated 6/12/2024, and thereafter where is the deputy commissioner's
62, my lord.
62, and thereafter the deputy commissioner Siaha district has also forwarded the
Reassessed.
reassessment award to the Undersecretary to the Government of Mizoram, Land Revenue and Settlement Department, Aizawl. Stop. And where is the letter
The approval,
to the
approval is at 68, Annexure 4.
page
68.
68? Thereafter, the Government of Mizoram, vide letter dated 5th June 2025, has approved the award as recommended by the District Collector of Siaha District. And a copy of the same has been forwarded
Yes, my lord.
to the respondents 1, 2 and 3. Stop. However, in spite of the fact that the period allowed by this court has already expired, the compensation award has not been paid to has not been dispersed to the petitioners. Stop. Para. Issue notice to the respondents, returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondents number 1 to 6 by registered
1 to
post.
7, my lord.
1 to 7 by registered post with AD and as well as usual process within 3 working days from today. So, at least after 4 weeks. Yes.
Obliged, Your Lordship.
Item 2.
May it please your Lordship.
What is this big petition?
My Lord,
Yes.
in this criminal petition, we have challenged the second FIR, the charge sheet, and the subsequent criminal proceedings.
It appears that
Yes.
similar petitions have already been filed, right?
Yes, my Lord. Several other analogous matters have been filed, and
At what
notices have been
stage are
issued.
they? They have been disposed of or
No,
still?
my Lord. No, my Lord. They have been listed together on 4/9/2025.
So these are all arising out of the same FIR?
Yes, my Lord.
Same case.
They are right now, Your Lordship, at the stage of filing objection, Lordship.
Okay. So can we list this along with the
I think
other
so.
petition?
My Lord.
Yes. Heard Mr.
Elgin Zoltan Moya.
Learned counsel for the petitioner who has filed the instant application under section 528 of the BNSS 2023 for quashing. Where is your prayer page? For quashing the FIR, charge sheet, and all subsequent criminal proceedings arising out of capital C and EO P/S case number 3 of 2024, including the supplementary charge sheet in C and EO PS case number 3 of 2024 under section 438/442. No, not that. What are the charge sections? Where is it?
Yes, my Lord, the charge sections 408.
No, where is that in your petition? In your petition, where have you stated?
Although we have not specifically stated the
Para
charge
3,
sections.
para 3. Under section 408/109/466/462/471/477A/120B and 34 of the IPC. Stop. It is the submission of the petitioner that earlier the FIR was lodged on 23/2024, which was registered as Aizol PS case. What was that first one? Aizol
PS 96 of
is
2000.
96 of 2024, dated 23/2024, and charge sheet number 170/2024, dated 10/7/2024, as well as supplementary charge sheet. Supplementary charge sheet number
Supplementary charge sheet number is, my Lord.
96 of 2024.
Yes, they are
No.
the same numbers.
same number.
Yes, same number.
Okay, 170 of 2024. Supplementary charge sheet dated 22/10/2024, which was made on the basis of the same set of allegations alleged earlier in the Aizol PS case number 96 of 2024. Stop. The learned counsel submits that since the basis for which the first FIR dated 23/24 and registered as PS case number 96 of 2024 are the same as the first are the same as the FIR in CNEO PS case number 3 of 2024, dated 29/3/2024, the instant application has been filed for quashing the same. Stop. Para. Issue notice to the respondents.
My Lord,
Written-
Mr.
yes.
Mr. Zoromsana and the
Okay, they are all
the
appearing.
government. Yes.
Notice to the respondents. Stop. Since the state respondents are represented by Ms. Mary L. Kente and you are for
I represent respondent number 3.
Mr. Such and such on behalf of respondent number 3. No formal notice is called for.
So with regards to
Respondent
respondent
two.
number 2, notice has to be issued.
For 2, no? So the petitioner shall take steps for service on the respondent number 2 by registered post with AD as well as usual process within 3 working days from today. And list the matter along with, just give the list of the other cases.
Criminal petition
Along-
18,
Criminal petition,
18 of 2024,
yes.
19 of 2024, 1 of 2025, 7 of 2025, 8 of 2025, 11 of 2025, 14 of 2025, 26 of 2025, 27 of 2025. My Lord, these matters have been fixed on 4/9/2025.
Okay, on 4/9/2025. The petitioner shall serve extra copies of the petition on the counsels for the respondents during the course of the day.
My Lord, deeply obliged.
For admission, item
Meanwhile,
3.
my lord, if I may kindly be allowed to file objection, Your Lordship.
No,
In the
that
meantime,
liberty is always
that
there.
may- that may be
The
reflected therein, my lord.
respondents are at liberty to file their objections, if any. Yes.
Obliged.
Obliged.
For admission, item 3.
May I please your Lordship?
Yes.
Lordship, I am appearing for respondents on behalf of Sanjay Kumar Mehdi. Lordship, here in this matter, the writ appeal is still pending before the principal judge and it has been fixed on 23rd 10/2025. So Lordship, kindly may fix the matter on 27/10/2025.
On 27/9. When do
10.
you want?
The writ appeal is fixed on 23rd 10. So Lordship, kindly may fix this matter on 27/10.
MS such and such, appearing on behalf of Mr. Sanjay Kumar Mehdi for the respondents. For the respondents,
Yes, Lordship.
My lord.
for the respondents submits that the writ appeal in connection with the present case is listed for hearing on
23/10/25.
23/10/2025. Stop, and accordingly prays that this present matter may be listed on 27/10/2025. So learned counsel for the petitioner has no objections to the said prayer. List on 27/10/2025.
Obliged.
Item 4.
This is also
Your Lordship,
contempt. Yes.
counsel for the petitioner is indisposed due to some personal difficulties. If the matter may be left that next week, if Your Lordship permits.
Okay. Otherwise, pleadings are complete.
Yes, Lordship, we
Filed.
already filed our show cause reply on 27 September 2024.
Okay. Heard learned counsel, Mr. Such and Such, who has made a mention on behalf of the learned counsel for the petitioner, Mr. So and so. Who are you mentioning on behalf of?
On behalf of Valentina Laldinpui,
Who is indisposed today, and accordingly prays for listing the matter after a week.
if Your Lord, if the date can be fixed.
Okay. After a week, so 4th, no, 8th. Let it come up on 8th. 8 September.
Yes,
Mm.
yes, Your Lordship.
Based on 8 September. Learned counsel such and such appears for the respondents number.
Item 5.
This is a jail appeal challenging the judgment and order dated judgment and order dated judgment and order and sentence dated 7/3/2023 passed by the Learned Special Court POCSO Act Siaha under Section 6 of the POCSO Act arising out of Siaha PS case number 34/2019. Stop. The appeal is admitted. Stop. We have to appoint an amicus. Any legal aid counsels here? Who is here? Who? Malswamy. Okay. Ms. Malswamy is appointed as the amicus for the appellant. Stop. The registry is directed to supply requisite copies of the documents to the amicus as well as the learned additional PP appearing for the state of Mizoram. Stop. Since this is a POCSO matter, the registry is also directed to serve notice on the informant/victim through the office of the PP, state of Mizoram. Thereafter, list the matter after 4 weeks.
Item 6.
Same thing. This is a jail appeal challenging the judgment and sentence dated 28/5/2025 passed by the Special Court NTPS Act Aizol under Section 22C of the NTPS Act arising out of Special Narco Case number 42/2022. Stop. Ms. Emily Jangte is appointed as the amicus to represent the accused in this matter. So the registry is directed to serve copies of the documents to the amicus as well as the learned additional PP appearing for the state of Mizoram. Stop. The appeal is admitted. Stop. Call for the trial court. In the previous case also, call for the trial court records. He's call for the trial court records from the court of such and such and list after 4 weeks.
Your Lordship, in the meantime, may I seek that, may I pray that the copy of the appeal petition be furnished to the office of the PP along with the notice?
Yes, we have already said to supply the copies.
Yes.
For orders, item number 7 to 23.
Your Lordship, this is an application under Order 1, Rule 10 of the CPC for seeking the leave of this honorable court for deleting or striking of the name of JICA, that is Japanese International Cooperation Agency. And in this case, Your Lordship, I am led by my learned friend Savita Sarna, and who is online.
Okay.
Your Lordship, I'm here on behalf of applicant along with my colleague. We have filed this application as my colleague has updated you. So, Your Lordship, we are looking for your favorable whenever you think you want to hear or you want to. I leave it on you what you want to. You want to hear the matter? I'm here to explain my case.
For deletion, striking out the name of such and such. Okay, who's for the other side?
We have served
My
the
lord.
copy to the learned counsel.
Yes, we have accordingly received. But my lord, although this is at the this is listed for the first time, I will want to raise some preliminary objections with
Oh, you
regards to
have
the maintainability
objections?
of this. Because yes, my lord, if I may take you to the order of this court dated 30/4/2024. we have implemented JICA because the learned court herein have stated that they are the necessary parties.
Order dated
34/2024.
Okay. Although several opportunities were need to file. Yes, it was on the direction of this court that JICA was impleted
Yes.
by order dated 34/24.
Your Lordship, we are conscious of this fact that it was issued on the instruction of on the direction of the Honorable this court only. Your Lordship, but we have a prima facie case where we would like to submit that our implement of JICA is not necessary for effective
Anyway,
adjudication of
the
this.
petitioner wants to file an objection.
Yes.
So just give them a short time to file the objections. Yes. The present application under Order 1 Rule 10 of the CPC has been filed, seeking the leave of this court for deletion / striking out the name of the Japanese International Cooperation Agency, JICA, in JICA within brackets, in the who have been impleted as respondent number 9 in the connected writ petition. Stop. The learned counsel for the I've heard learned counsel for the petitioner, MS such and such, as well as MS Mary Kante for the petitioners. Stop. No, sorry, the applicants / respondent number 9. Stop. At this stage, the learned counsel, Mr. Such and such, appearing for the petitioner, has prayed for a short time to file his objections in the present application. Stop. Accordingly, how much time?
2 weeks, my lord.
2 weeks. Accordingly, the learned counsel for the petitioner is granted 2 weeks' time.
Your Lordship, a date may be fixed so as to make the convenience of my learned.
Yes, to file an objection in the present application. So place the matter on. So after 2 weeks, that is 15th September or 16th.
Any day,
I
my
think
lord.
Your Lordship, 16 may be better in case we need to come from Delhi if the weather permits. So 16th is better.
16th
date.
September 2025.
Your Lordship, another just want to point out, they are using the word for us, Japanese International Corporation. It is Japan International Corporation. It is wrongly written typo.
Oh, not Japanese International. Okay.
It is Japan. It is Japan International Corporation
Japan
Agency.
International Cooperation Agency.
So order can reflect the correct name.
Yes.
Obliged.
My lord,
Yes.
item 7 is a bit different from item 8 to 23. Because in item 8 to 23, we have challenged the notification of the government, and we have not challenged the guidelines of the JICA. So if item 7 may be segregated
So
from
it
item
should be
8,
segregated.
yes, it is not the same. 8 to 23 are the same.
8 to 23 are the same, and item 7. Yours is item?
Item 7 is different. The ones that my learned friend is
okay.
appearing.
Okay. So it is also stated by the learned counsels appearing in item number 7, just give the case number, that this case may be segregated from the rest of the writ petitions. Stop. As the facts and circumstances are not similar. Stop. Accordingly, prayer is allowed. WPC such and such, item 7, okay, may be segregated from item number 8 to 23. And list when?
And in item 8, my lord, the pleadings have been completed.
Item 8, 14, 15, my lords. Item 8, 14 and 15.
Item 8, 9 also. 8, 9, 14 and 15.
8,
Pleadings have been
9,
completed.
14 and 15 pleadings are completed.
And 10 also.
10. Okay, so in 8, 9, 10, 14 and 15, then we'll list it for hearing.
Yes, it can be listed for admission hearing, my lord.
These 8, 9, 10, 14, 15 listed for hearing in usual course.
Yes, my lord.
Right.
13, my lord, 13 also.
Lordships, if we may just repeat the item numbers where pleadings are complete. 8,
Yes.
9, 10, 13 to 15.
Oh,
13,
8,
14,
9, 10, 13, 14, 15.
Yes.
Yes, my lord.
8, 9, 10, 13, 14, 15. Okay, so those will be for hearing in usual course. And 7 segregated. No? Yes.
Obliged, my lord.
No, 7 is segregated, okay. There will be some confusion, okay. There are similar orders you pass in each writ petition for hearing. Then in item 7, you say to segregate it from the rest of the matters and list it separately. Then what about the other matters?
The other pleadings are not yet completed, my lord, but it's similar matter, so it can be taken along, my lord.
So which are the other matters where pleadings are not complete?
Such as 11,
11,
12,
12,
16, 17
16.
to 23.
16, 17,
18, 19, 20, 21, 22, 23.
okay, 18, 19, 21, 20 also?
Yes, my lord.
20, 21, 22, 23. In these matters, affidavits are not filed.
It's not yet completed.
Counter
Some
affidavit.
have been filed, but not yet completed by the respondents.
So in these matters, you say that pleadings are not completed. Accordingly, the respondents are granted. That means respondents have to file the affidavits.
Yes, my lord.
The respondents are granted another 3 weeks' time, 3 weeks' time to file their affidavit and oppositions. It's least after 3 weeks.
Lordship,
Okay.
in the meantime, if I may be allowed to make one more prayer with regards to item number 22 and 23, wherein we have inadvertently put the wrong address as for respondent number 4 as Nathiel district, whereas it should be Lunglei district. And if I may be allowed to amend the course title in these 2 items, item 22 and 23.
Item 22 and 23.
Yes, Lordship.
I think it's better if you file an IA, no?
Okay. Yes, Lordship.
You file an IA. Yes. Then any more? Have we covered all? Because this till 29, na? Analogous? Oh, till 23. Okay.
Till 23.
Okay, okay. Yes.
The confusion is some of the matters where the pleadings have been completed
Huh.
has to be listed for hearing, and the remaining has to be listed for admission.
Yes.
But they're not clubbed together as of now. So
Because of the CIS, this problem comes up, na? Unless there's an order. See, now that we have the CIS, when matters are linked up together, it is difficult to segregate them. Unless there's an order segregating, then only it will be entered in the CIS. So it will all come up together.
Item 7 is a bit different because they are challenging.
No,
the
item
policy of
7
the-
already order is there to
Yes.
segregate, so that
The
is
rest-
segregated.
Let it come up together. It's
It can all come up together, Your Lordship.
It has to come up together.
Yes, it can come up together, my Lord. Even if the
So-
pleadings are complete or not complete,
Yes,
they can
yes.
come up together. It's the same subject matter.
Yes, yes.
item
So,
8 to 23.
so in the other items, we have said list for hearing in usual course, na? After 4 weeks, isn't it? So let the others also come up after 4 weeks.
Yes, my Lord.
My lords, just one clarification.
Yes.
Item 8 to 12, 23, your lordships has said that it comes together. We have no objection, my lords. Just that, my lords, in those items which we have mentioned that pleadings are complete, that may be mentioned, my lords. Or else again, time would be sought and the matter would be protracted.
No, we'll give a direction. We'll say that before the next date, the affidavits should be filed. Yes.
If the completed pleadings are concluded, it would cover all the rest which are not even completed, my lord. So it's okay. There's no problem.
It's the same thing then.
It's the same thing.
Yes. So, in those cases where affidavits are not filed, you just say before the next date, the affidavits, counter affidavits of the respondents shall be filed.
Grateful, man.
And then let it all come up together. Okay.
Item 24.
May I please, Your Lord? All of this condonation application is for condonation of 155 days in filing an appeal against the judgment and order 17/12/24 passed by the Additional District Judge Scholarship.
Okay.
So this is the first time it's listed.
Okay. Heard learned counsel for the applicant, Mr. Lalfaxwala. Stop. This is an application. This is an application under Section 5 of the Indian Limitation Act, under read with Order 41 Rule 3A CPC, praying for condonation of delay of 155 days in filing an appeal against the impugned judgment and award dated 17/12/2024, passed by the learned Additional District Judge Aizol, Judicial District Kolasib, in LA case number 28 of 2025. Stop. Para. Issue notice to the respondents returnable within 4 weeks. Stop. The petitioner shall take steps, the applicant shall take steps for service on the respondents. 1 to 14.
I'm appearing
1
on
to
behalf of respondent 13 and 14.
Okay, respondents 1 to 12. Stop. Learned government advocate such and such accepts notice on behalf of respondent number 13 and 14. Hence, no formal notice is called for. Stop. The steps on respondent 1 to 12 shall be taken by the petitioner by registered post as well as usual process within 3 working days from today. Stop. List after 4 weeks.
Item 25.
My Lord, in this case, there is a delay of 156 days. The impugned judgment and order is restored.
So, similar order, but the delay will be 156 days, and the judgment and award is dated 17/12/2024, passed by the learned Additional District Judge Aizol, Judicial District, Kolasib, in LA case number 31 of 2015. And here also, government advocate accepts notice for same
Respondent number 9 and 10.
respondent number 9 and 10, and 1 to 8 by registered post with ED. No? Similar.
Obliged.
Item 26.
And 4 weeks notice returned within 4 weeks.
Lordship, there is a delay of 135 days in filing an appeal against the judgment of the learned commissioner. And this is the
135 days. Okay. Learned counsel for the petitioner, Mr. Such and such. Stop. This is an application under Section 5 of the Limitation Act, praying for condonation of delay of 135 days in filing the connected appeal against the impugned judgment and order dated 7/2/2025, passed by the learned commissioner, employees compensation, Aizol, Mizoram, in EC case number 9 of 2021. Stop. Para. Issue notice returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service on the respondents number 1, 2, and 3 by registered post with AD, as well as usual process within 3 working days from today. List after 4 weeks.
Item 27.
May I please, Your Lordship, my Lord, this also is an application for condonation of delay. Number of delay is 31 days. Respondents are father, daughter, nephew, and niece, and they are in the same house.
Even if it's 1 day delay, we have to
Yes.
issue notice.
My Lord.
Lord Learned Counsel for the appellant / applicant, Mr. Such and Such. Stop. This is an application under Section 5 of the Limitation Act, praying for condonation of delay of 31 days in filing. 31.
Yes.
31 days in filing the connected MSc appeal against the impugned judgment and award dated 22/4/2024, passed by the MSCT Aizawl, Mizoram. Stop. You are appearing for?
I appear for respondent number 1 to 4.
All the respondents,
respondents.
claimants.
No, you have already filed your power.
No, Your Lordship, if I may be given 1 week for filing my power.
Stop. Learned counsel, Mr. Such and Such, submits that he has instructions to appear for the respondents number. All the respondents.
Yes, Lordship. And also I will be, if I may be allowed to accept notice on behalf of the respondent as well. Today.
Yes. To receive instruction to appear on behalf of all the respondents. Stop. Hence, no formal notice is called for. Stop. The learned counsel for the applicant/appellant shall serve extra copies of the petition on the learned counsel during the course of the day. Stop. You want to file any objections?
Lordship, if I may be given 1 week, in the meantime, I will
Okay.
also.
31 days, I think. Anyway, you get the instructions. Yes.
Yes.
Stop. The learned counsel for the respondents is also given liberty to file an objection within 1 week, if so advised. Stop. List after, and he has also, and he's also allowed to file his vaklatnama. Stop. List the matter after 2 weeks.
Much obliged.
Obliged.
Item 28.
May it please Your Lordship,
Yes.
this is an application for condoning the delay of 2552 days. However, as per the calculation of the registry, which is minusing 716 days due to COVID pandemic, it's 136 days. However, I would like to mention herein that the applicant herein has recently attained majority, and the impugned heirship certificate in the order which we have challenged was passed when he was a minor, and he had gained knowledge only a few days. He had gained knowledge only on 31/9/2024, wherein a subsequent heirship application has been filed by his cousin. So the actual delay is only 325 days. So if Your Lordship permits, notice may be issued to the respondent.
That is a question to be
Yes, it will be.
adjudicated. Yes.
Yes.
This is an application under Section 5 of the Limitation Act, praying for condoning the delay of 2,552 days in filing the connected RFA against the impugned order dated 29/5/2018, along with the impugned heirship certificate number 555 of 2018, passed by the Court of Senior Civil Judge 3, Aizawl Judicial District, Aizawl, in heirship certificate case number 555 of 2018. Stop. Heard learned counsel for the petitioner, Shri such and such. Stop. Issue notice to the respondent, sole respondent, returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondent by registered post with AD within an usual process, as well as usual process, within 3 working days. Stop. And thereafter list the matter after 4 weeks.
Obliged, my Lord.
Item 29.
My Lord, this is also an application for condoning the delay of 667 days. This IA, the previous IA, I have withdrawn with liberty to file afresh on Tuesday, if I remember correct, because there was some defect.
You said there was some defect.
Yes, I have failed to minus 90 days. But now office note indicates that I have to add another 7 days.
Yes, and then you have to annex a copy of this court's order allowing you to withdraw also. Have you annexed?
That I have not annexed, my lord, but
you have to annex that and then explain that this court had allowed to withdraw.
yes.
And so you have to count that those days
Yes,
also.
my lord, due to the server problem, I could not obtain a copy of the order. And since this matters requires some urgency, I immediately filed it the following
But
day.
have you at least stated in your pleadings that
No,
you, that
I
you
have not, my lord.
withdrawn?
Since it pertains to a fact, I have not stated it. But nevertheless, my lord, the delay could only be 667 days because I have not withdrawn the RSA. This is only an application for condoning the delay of
No. See, the RSA cannot be admitted unless the
Yes,
condonation
but
is...
the RSA has been filed on 19/8/2025. So if it's filed on 19/8/2025, the delay should be 667 days and another 7 days could not have been added because it's already been filed in the court, my lord.
No, see, learned counsel, the moment you withdraw your condonation application, it is
The
the whole
RSA
RSA also is gone.
my lord. The RSA is still there. The RSA is still there before the court. The filing date remains the same. Everything remains the same. I only withdraw the IA because there was a defect.
What defect was there?
The defect was that I failed to minus 90 days in the previous application. And the registry also recalculated the days, saying that 90 days has not been minused by the appellant, and the delay should be 667 days. So I filed an application for 667 days, and they said that number of days should increase when the appeal is still lying with the registry, my lord. It's before this court. The filing date remains the same. It's only with regard to the IA, and the IA is only for condonation of delay with regard to the admission of the RSA.
No, learned counsel. See, when you withdraw, then automatically it goes...
No,
It goes...
no, my lord. The RSA is still there. I can file the RSA without filing a condonation of delay also, and the registry will inform me that there is a defect and you have to file the condonation of delay. Then the number of days will remain the same, because the number of days cannot be different, because the RSA has been filed on 19/8/2025. If I was to add another 7 days, how will I explain? There will be an additional 7 days.
No, that you can always explain, saying that
Yes.
after 7 days it was withdrawn, so that period was spent within that,
My lord,
that 7 days.
uh,
That can be easily explained.
Before also we used to have this, whenever there was a defect in the condonation of delay, we used to withdraw and we used to file it afresh, but the number of days remained the same because the RSA has already been filed. If I withdraw the RSA in the previous court date, then the number of days will increase eventually, but the RSA has not been withdrawn. It's only the IA that has been withdrawn, my lord. If you go to the RSA, it will say that it has been filed on 19/8/2025. The seal will indicate 19/8/2025. The seal will indicate that it has been filed before this honorable court on 19/8/2025. So computing from the date of the impugned judgment and order, dated 24/7/2023, minusing 90 days.
No,
the
but
delay
again,
would come
learned
to
counsel, see, the
667.
fact that you were allowed by this court to correct your mistake, that also is not stated anywhere. You have not stated that I have withdrawn and this is a fresh application. That also hasn't been stated anywhere.
With regard to that, I apologize, my lord, because
At least that has to be stated,
since I am unable to obtain a copy of the order, due to their server problem.
No, because that has to be brought to the notice of the court, because there may be a different bench.
It may
So
be a different bench, but
yes,
my
how
lord,
will the court know that you have withdrawn and you are filing it again?
my lord, the disposal order will still be there in the connected file, my lord. I don't think that will create a problem in future. Nevertheless, my lord, I don't know how.
I think you will have to add one paragraph.
Yes,
Okay.
that I
You
can
will have to
add.
add one paragraph. You refile it. Learned Counsel is allowed to withdraw the IA with liberty to file a fresh.
My lord,
You
if the
put-
number
you-
of days can be clearly mentioned, because they will create some problem in the registry again, because they will have to say that I have to add another days.
No, you file it today itself, and then we'll consider. We'll see on Monday.
Okay.
Okay. You add that one paragraph saying that you have withdrawn on such and such date, and you're filing it. That has to be
My lord,
there.
if your lordship permits, it may be stated that the RSA has not been withdrawn by the applicant. Then there would not be a problem. Only the,
We'll see on the next day after you file it. We'll pass necessary order.
Okay, my lord. Obliged, my lord.
Hearing list, item 8.
Yes.
My lord,
Yes.
this is a petition filed under 227 of the Constitution challenging the Lok Adalat award, my lord. And the
It's
Lok
very
Adalat-
limited. Very limited.
Yes, it's limited,
thing.
my lord.
Yes.
I agree.
Limited scope.
Yes.
Only if it is some fraud is
The
there.
Adalat
Or yes.
translation copy is in page 3 of my petition, my lord.
Hmm.
May I read out the award, my lord?
Yes.
From second page, second para, my lord. First para is the
Yes.
format, my lord. Second para, my lord. Today, on this the 13 August 2022, the petitioner Van Rofili of Vaivakon and opposition party Lel Rohlua, Lel Zaomi, Lel Sang Zoli, and Thang Dailova are present. It is agreed that House Site number 124 dated 22nd June 2019, which is presently owned by Sri Lel Rohlua, son of Frankie Makanan, which used to be in the name of Srimati Lel Sang Zoli, wife of H. Sangmoka, be mutated in the name of Sri C. Leltran Puya, son of Sri Thang Dailava, Sesong 3. The land and anything standing therein shall be next
Owned by him.
To settle this, Sri Lel Rohlua Lawa Kanan and Sri Leltran Puya, in order to help Srimati Lel Sang Zoli, shall hand over 10,000 each within August 2022. Apart from this, R. Zonun Sangi, daughter of Srimati Lel Sang Zoli, shall continue to stay in the house where she presently stays till December 2023. She shall also receive house rent till August 2022. Sri C. Leltran Puya shall receive from next month. Srimati Lel Sang Zoli demands 4,50,000 from Van Rofili as she had sold their land. Today, on this the 13/8/2022, she pays 50,000 forthwith. The balance 4 lakhs shall be repaid monthly. This arrangement has been made by the party unanimously, my lord.
And you have also signed.
We signed, but my lord, all the parties did not sign the Lok Adalat award, my lord.
Yes. So your name is
Lel Sang Zoli, my lord. I'm standing for the petitioner, my lord.
Your
My lord, if-
your name is it's serial number 3 in the
Yes.
in the award, and you have signed also.
I did sign, but all the parties did not sign the Lok Adalat award, my lord. And the award is not a consent award, my lord. My lord, if I may take my lord to second para of the Lok Adalat award, which starts today on this the 13/8/2022.
Yes.
The petitioner Van Rohili and of Vaibakon and opposition party Lel Rohlua, Lel Zaomi, Lel Sang Zoli and Thang Dailova are present. And if we turn the next page again of the Lok Adalat award, my lord, page 4, wherein parties have signed the signature, my lord, under the opposite party, my lord. Name Lel Rohlua, signature is there. Lel Zaomi, signature is there. Lel Sang Zoli, signature is there. Page 4, my lord.
Yes. Okay, and who was not present?
Thang Dailova, my lord. From the second page of the Lok Adalat award, my lord, it's quite clear. His son signed on his behalf without having any power of attorney or any document to sign on behalf of his father, my lord. My lord, may I submit?
But this petition is filed by this Lal Sangzwali,
Yes, my lord.
who has already signed.
Our signature is there, my lord, but my one point of argument is all the parties did not sign the Lok Adalat award, which means the alleged award is not award, according to me, my lord. May I submit this documents, my lord? Yes, me my. My lord, before I argue on the law point, may I clarify the facts to my lord?
Oh,
My lord?
okay.
Facts of the case, my lord. Basically, my lord, the problem arises in this case is
No, what was the dispute about? Just tell me that.
1 minute, my lord. My lord, basically, the respondent number 5 borrowed an amount of 50,000 from the respondent number 1, my lord, to respondent number 2.
Respondent 5
Borrowed an amount of 50,000 from respondent number 1 to respondent number 2, my lord.
Respondent number 1. Okay.
Shall I read?
Yes, yes.
Page number 31, my lord.
Page?
Page 31, my lord.
31.
My lord, before reading page 31, may I read page number 49, my lord, the application of the Lok Adalat. From here, I think it's quite clear about the facts, my lord. 49 and 51 is the English translation, my lord. English translation is in 51, my lord.
Okay, okay. Yes.
This is an application filed by respondent number 5 for Lok Adalat, my lord.
Page 51.
51.
Letter to,
May I read the
this
content?
is the letter to the member secretary.
Yes, yes.
State Legal Service.
From here, I
Yes.
think the facts are quite clear, my lord.
Yes, yes. This is
In 2018, since I was in dire need of money, I requested the petitioner to let me use their VC pass in order to borrow money. Understanding my situations, they agreed and allowed me my request. Then I borrowed 50,000 from Rohlua, is the respondent number 1, my lord, to her sister, who happens to be respondent number 2 in petition, my lord.
The sister is our respondent?
Number 2, my lord.
Number 2, okay.
Then I borrowed 50,000 from respondent number 1 to respondent number 2. Out of the said money, an amount of 50,000 has been handed over to the petitioner in order to thank her. And I also handed over 5,000 to respondent number 2, who is the sister of respondent number 1, as was expected by her. That the main purpose why I borrowed this money is to start my living by earnestly selling vegetables. I am a widow raising 2 children and taking care of my elder sibling. I cannot repay back the money in lump sum. When I tried to repay back in installment, they refused to accept it. I really feel indebted and guilt to the petitioner and her family. However, they still understand my situation. When I really need money, my father gave me 30,000 from the money he received as land compensation. From the said money, I tried to give 20,000 as first installment. Sister of Lal Rohlua Rohlua is the respondent of loan. Sister of Lal Rohlua tried to accept it as an interest of the loan amount.
And who's the sister? Sister is also a party?
Yes, respondent number 2 in the petition, my lord.
Oh, R2. Okay.
We want them to receive it as principal amount. This difference of opinion regarding the calculation, we cannot accept the proposal made by the sister of Lal Rohlua, respondent number 1. Respondent number 1 then filed the case against us before the BC court. Respondent number 1 herein, my lord, filed a case to recover the 50,000 in the BC court, who have no jurisdiction, my lord.
What is VC court?
Village council court, my lord. Lal Rohlua then filed a case against us before the village council court. I was ordered. Village council court, without having any jurisdiction, ordered to repay the money on or before 1st June 2019. And the petitioner also agreed to give in case if I cannot repay the money. That due to COVID-19 pandemic, I face serious difficulty in repaying the money. I informed the respondent number 1 and he understands me. Since they want to receive money only in lump sum, I then start saving money. While I am still struggling, on 24th July 2022, respondent number 1 sold to respondent number 3, my lord.
Sold what?
That
mortgage land?
Exactly, my lord.
Oh.
Though it's not on record, I heard that the respondent number 1 sold to respondent number 3 for an amount of 3 lakhs, my lord. That due to decline in COVID-19 cases, I can now start saving money. Why, when I am in the process of repaying the money, I really cannot understand why they have sold the land to Thangdailaba. The prayer in the Lok Adalat application, my lord. I please beg you to take necessary steps so that the land which has been sold is in the hand of the petitioner. That I am in a better position to repay the money which I borrowed. I also wish and expect that those persons who have used my money to repay me back, my lord. Basically, the respondent number 5 filed a Lok Adalat application to get back the land, which was already sold by respondent number 1 to respondent number 2, my lord. And my lord, if I may take my lord again to page 31 of my petition, my lord. Please clarify the application of the respondent number 5.
31.
31.
Yes.
May I read out, my lord? I, Lal Rohlua, who is the respondent number 1, lent money 50,000 to Vandropili, respondent number 5, on 5th January 2018 by mortgaging this VC pass to be repaid back on 5th April 2018. In case it is not settled within this period, they shall not have any say in respect of the VC pass, my lord. Again, my lord.
What is this? What is this?
This document is nothing. It's a document which shows that the respondent number 5 borrowed an amount of 50,000 from respondent number 1. Though no written letter is there, no written agreement is there between them. Seems like
SVC number 107, dated 15/17/2008. So what is SVC?
Sesong Village Council, my lord. The place where this property is situated, my lord.
So they have made an agreement before the village council.
It seems, my lord, because I cannot file the application filed by respondent number one. Cannot obtain from the BC court. It's not available, my lord. So whatever document I have, I submitted in my petition, my lord.
So this is an agreement saying that the R1 had lent the money to R5.
Exactly, my lord.
That's
Since
all.
the respondent number one filed the application to get back that 50,000 money, my lord, that BC court without having any jurisdiction, it seems like they try to settle the matter, my lord.
Okay. Now come to the Lok Adalat.
Again to page 34, my lord.
Page?
Page 34.
This is also village council.
Yes, village council. As I keep repeating, my lord, village council court without having any jurisdiction tried to settle this matter, my lord. In fact, they mutated without having any jurisdiction, my lord. May I read out again, my lord?
Yes.
The village council court meeting begins under the chairmanship of chairman. Agenda number 1. Letter submitted by Lel Rohlua. Rohlua is the respondent number 1, my lord. Lel Rohlua, as asked by the chairman, explained that he approached village council court session because Van Rohlili did not repay his money within the time frame as agreed. Van Rohlili, Lel Sangzoli submitted that, see, my lord, here it's quite clear. Lel Sangzoli submitted that she is not ready to surrender oblique laws her village council passed, mortgaged by respondent number 5 to respondent number 1, and further submitted that out of sympathy to respondent number 5, she agreed to lend her village council pass as mortgage property by borrowing 50,000 from respondent number 1. The petitioner wished that respondent number 5 repay the money borrowed by her to respondent number 1. Respondent number 5 affirms that she borrowed money from respondent number 1 as she is in dire need of money. She plans to repay as and when compensation is received. However, since money received from compensation is insufficient, she could not repay the money.
Okay. So now this petitioner is actually, she is the owner. She is the
Petitioner
village
is the
council
owner of the
pass,
BC pass, my
owner
lord.
of the
Yes,
property.
my lord.
But she had lent it to this Van
Yes, the
Rohlili.
petition number 5, my lord. To be mortgaged to respondent number 1, my lord.
Okay.
To this letter, my lord, the time is extended again. If I may read the last para, my lord, page number 35. May I read on, my lord?
Yes, please read.
Respondent number 5, daughter of Buantua, by Baconizol, undertakes that I shall repay the money borrowed by me, 50,000, latest by 1st June 2019, along with interest, that is 5,000, totaling 55,000. Petitioner also agreed to give her a brick house site at CTI in case Van Rohlili fails to repay. Chairman did not sign this letter, my lord.
So ultimately, after this, it was sent to the Lok Adalat.
Before it was sent to Lok Adalat, my lord, this BC pass, it's already been mutated in the name of respondent number 1, my lord. At the time of sitting of the Lok Adalat, the petitioner is powerless to say anything in this regard because her land is not in her name anymore, my lord. May I take my lord to page number 44 and 45. My lord.
44.
Yes, 44 and 45. 44, no relevant thing is there, only the date, my lord. 44, time is village council court sitting, the 124th sitting. Date, time 22nd June 2019.
22nd June 2019. Yes. In this, what did it say?
In this, page 45, my lord. Agenda number 10. As passed by village council sitting number 118, that if respondent number 5 fails to repay 50,000 along with interest to respondent number 1, house site owned by petitioner shall be mutated in the name of respondent number 1. That till today, 22nd June 2019, the borrowed money has not yet been repaid. After sincere discussion regarding the house pass, which is in the name of the petitioner presently, as requested and asked by respondent number 1. It has been decided by the meeting that the House pass of petitioner shall be mutated in the name of
No, Lal Rolua is R5, isn't it?
No, Rolua is R1, my lord.
R1, oh.
Yes.
Oh, yes. R1. And this is very confusing, huh?
Yes, yes.
And Van Rohili is R5.
It's the R5, my lord.
Okay. It's been decided by the meeting that...
Meeting minute is in page 45. And the date is 22nd June 2019, my lord. And it seems on the same day that VC pass has been mutated in the name of respondent number 1. If I may take
How
again,
can that be?
my lord?
How can that be? When you are the owner.
Exactly.
And
my
without...
lord, again, page 46. If I may take my lord to page 46. May I read out my lord again? Oh, no, my lord, 46 is the Mizo. 47 is the English translation. May I read out page 47 again?
Yes.
Village Council Court sitting number 124 dated the 22nd June 2019 after careful deliberation has granted to the under-mentioned person house site, oblique garden, agricultural and terrace playground as details below. And on 22nd June 2019, my lord, the owner is already transferred, already mutated. R1 is the owner, registered owner, it seems, from the document, my lord.
So have you challenged this?
My lord, because of this Lok Adalat, I cannot challenge, my lord.
Oh.
That's why I'm challenging right now, my lord. The Lok Adalat award is in the date of the Lok Adalat is, my lord, 13/8/2022. 13/8.
1 minute. By annexure 5A, so how is the land pass given? It's given by the village council, the land pass.
It's given by the village council, but when it is to be cancelled, my lord, I have to violate the terms and conditions of the VC pass. I did not violate anything. Just because I mortgage the property to someone else, it cannot be mutated in the name of third party, my lord. And again, my lord, this mutation happens on 22nd June 2019, much prior to the date of Lok Adalat, my lord. Date of Lok Adalat is 13/8/2022, my lord.
And this mutation by the village council is 22/6.
Yes, 22/6/2019.
22/6/2019.
2019. And the date of Lok Adalat is 13/8/2022, my lord. Some of the Lok Adalat award is a very one-sided award, my lord.
So in that case, before it was put up to the Lok Adalat, what did you do against this 22/6/2019?
It was during COVID-19, my lord. My client did not do anything, my lord. Some of the minute and the mutation done by the village council pass was like approved. It seems, according to my understanding, it was approved by the Lok Adalat, my lord. Though the application filed by respondent number 5 was to take back the land, but the award pass was against even respondent number 5 also, my lord.
Okay, then after this 22/6/2019 order, what happened?
After 22/6/2019, my lord, respondent number 5 application to get back the money, the land, my lord, which I just read out, my lord. It's in page 51.
That 51.
Yes, application filed by respondent number 5, not by me, my lord. It's by respondent number 5. In the prayer, last 52, last para, my lord.
Please beg you to take necessary steps so that the land which has been sold is in the hand of the
Though it was actually not sold, but it was mutated. Seems like some misunderstanding on the part of respondent number 5, my lord.
So she has, R5 has written to the member secretary,
Yes.
praying that the land should be given back to you.
Yes, my lord. And my lord, the Lok Adalat, after the Lok Adalat application has been filed by respondent number 5, Lok Adalat sitting was held on 25th July 2022, my lord. First date it seems 25th July 2022. It's in page 54 of my petition, my lord.
And next year, 7.
Yes, my lord.
Page
Yes, yes, sir.
54.
It seems 3 dates were given by the Lok Adalat, my lord. And Lok Adalat award is on 13/8/2022, my lord. And may I continue, my lord?
1 minute. Petitioners are present in person, family, what is good. Yes.
Aggrieved by the Lok Adalat, my lord, the daughter and husband of the petitioner filed a review application before the Lok Adalat. That is on, I don't know the date of application, but the receipt by the member secretary is on 18/8/2022. Lok Adalat award is 13/8. Soon after the passing of Lok Adalat, application to review Lok Adalat has been filed. May I read out the
Where is that?
page 57, English translation, my lord.
Page
57, 57, my lord. Application to review Lok Adalat award. Sir, on 13 August 2022 in Lok Adalat pre-case number 357 of 2022, agreement has been entered with regard to the house where I presently stay. She is the occupant of one of the house, my lord. According to this agreement, I will have to vacate this house. I am a widow having 3 children. I have no other house. I am unemployed having no regular income. If I have to lose this house, I will have no other place to stay. I will not be able to afford other house. My parents are old and are not in a position to give me other house. Looking future of my children into consideration, this Lok Adalat agreement may kindly be reviewed and hold the persons who were parties.
After that,
And
page
since
59.
the members of this legal Mizoram State Legal Services Authority, my lord, advised the applicant of the review application that it was not within their power to review the Lok Adalat award. She filed an application again to withdraw the application. That is in page 62. Page 62, my lord. May I read out again? Subject to withdraw the application submitted for review of the Lok Adalat award passed in Lok Adalat pre-case 357 of 2022. Sir, that on 12/8/2022, Lok Adalat award has been passed. The date is a bit wrong, my lord. Typographical error, it seems 13/8, it has to be 13/8. Passed in respect of our house and land located at CTI in our absence. To review this Lok Adalat application dated 18/8/2022, receipt number 26388 has been filed. After consulting advocate, we wish to take appropriate legal action. Hence, we seek to withdraw the review application. Since they were advised that the Lok Adalat do not have any power to review, they withdrew the application. And my lord, at this time actually I was advised, I was consulted. But since I don't see the house pass or any document related to the house pass, so we find again application. Another application.
Again, another application for review.
Yes, madam.
Page 63.
It's in page 67, my lord. Page 67. The relevant part will be in my lord, page 68, last two lines, my lord. May I read out again, my lord? 68, my lord. That application was purely filed to get the photocopy of the house pass, my lord. PC pass, sorry. So that I can show before this one. Second two lines, my lord.
Yes.
That I do not have either my original or duplicate copy of the village council pass of my land located at CDI Sesong. I humbly pray that any photocopy or original village council pass that belongs to me but is presently in possession of Lelton Puya shall be taken and handed over to me. And again, that application was disposed on 13/5/2022, my lord, which is in page 69. Even to see or even to get a photocopy of the VC pass, my lord, we were not allowed. Even the house photocopy of the VC pass were not handed over to us, my lord. It's in page 69, my lord. At the time of this Lok Adalat sitting, I was there, my lord. May I read out again, page 69, my lord.
So they refused to hand over the VC pass.
Not
R1.
Our prayer basically was not the original. Even the photocopy, we want to show to the Honorable Court, my lord, because at that time we intended to file a petition challenging the Lok Adalat award. The order is there in page 69, my lord. May I read out again, my lord?
Yes, yes, I've seen.
All parties present. A petition for recovering of VC pass number SBC 107/5/08 issued by Sesong Village Council in favor of the petitioner has been filed by the petitioner of Chan Mari West Aizol against Lelton Puya Raulua, Zaomi and Van Refiling. The matter is deliberated at length. It is submitted by the petitioner that C prefers to challenge the award dated 13/8/2022 in the High Court, and for this purpose C needs original and photocopy of the village council pass, which is alleged to be in the possession of the respondent number 1. Next, page 7. During deliberation of the matter, respondent number 1 strenuously refuses to hand over the said VC pass. Upon consideration of the matter, this bench of Lok Adalat is of the considered view that no settlement could be arrived. Hence, parties are advised to appropriate forum to seek remedy. Accordingly, the instant petition stands disposed of. So we were not given either original or photocopy of the VC pass. The rest documents are the correspondence between the village council and me, my lord, wherein I inquire whether the whether mutation has been further made from the respondent number 1.
Okay. So now your prayer is, where's your prayer portion? Page?
Prayer portion,
Yes. Okay. between Lok Adalat award passing and such. Suspend operation of okay. So you're basically you only one day Lok Adalat award to be set aside so that you can pursue the yes.
Because this Lok Adalat somehow affirms the decision made by the village council past. My lord, may I take my lord to the documents which I just submitted, my lord.
No, just come back to the award again once. Now I can understand better, I think. Yes. Dispute between the parties have been referred to the petitioner.
The first line and the last line are formatted, my lord.
That the house
prepared by
is
Nursa.
personally owned by such and such used to be dictated in the name of yeah. Handover. State house. And who is staying in the house now?
My daughter is staying in the house, and she also was not made a party in the Lok Adalat, my lord. In fact, she is a necessary party. That is one point of my argument, my lord. Till date, she is still staying in the house, my lord. My lord, may I submit again another one document, my lord, so that my lord can understand the fact. My lord, if you see the picture which I just submitted, my lord, there are two some type building in the land. Building number 1 is occupied by my daughter, and prior to the BC minutes, actually we rented out to another person, the building number 2. Building number 1 is occupied by my daughter, and number 2 is by tenant. And because of the Lok Adalat, actually we stopped taking rent from building number 2. But till date, my daughter stay in building number 1, my lord.
And which was the building which was mortgaged?
Not the building, the land.
Oh, the land, the land.
Mortgage, my lord, exactly. Even only this building number 1 is worth more than 50,000, my lord.
Okay, yes.
To the document which I submitted, my lord. My lord, if I may take to page number 7 of the documents which I submitted. Page 7. This first document is the Mizoram Civil Codes Act 2005. Through this document, I try to show my lord that BC court has no jurisdiction to settle the matter. The 50,000 money lent by respondent number 1 to respondent number 5, my lord. Page 7, my lord. Section 14 and 15 are relevant, my lord. May I read out section 14, my lord?
With the judgment?
Not the judgment, the Mizoram Civil Courts Act, page 7, my lord.
Oh, page 7.
Pagination is there.
Yes.
Jurisdiction of a court of senior civil judge. The jurisdiction of the court of a senior civil judge shall extend to all original suits and proceedings of a civil nature, the value of the subject matter of which exceed 2 lakh rupees or such other sum as the High Court may from time to time specify. The jurisdiction of the senior civil judge, earlier it used to be above 2 lakhs, my lord. And again in page section 15, jurisdiction of a court of civil judge. Now civil judge junior division, my lord. The jurisdiction of a court of civil judge shall extend to all original suits and proceedings of a civil nature, not otherwise excluded from the jurisdiction of a court of civil judge by any law, the value of the subject matter of which does not exceed 2 lakh rupees or such other sum as the High Court may from time to time specify. From this, I try to show that, my lord, the money borrowed is only 50,000. It has to be brought before the civil judge,
Junior division.
Exactly. And amendment is there in the civil court, my lord, Mizoram civil court, which is in page 15, my lord. There's 2 lakhs, it's been raised to 5 lakhs through this amendment, my lord. May I read out again, my lord? Page 15.
Yes.
Page 15. Amendment to section 14, which is in section 2, my lord. In section 14 of the Civil Courts Act 2005, hereinafter referred to as the Principal Act, the words 2 lakh rupees shall be substituted by the words and figures 5 lakhs. So the Civil Judge Junior Division has the power to try property worth, the issue
Up to 5 lakhs.
Exactly, my lord. And which is below 5 lakhs, it has to be the junior Civil Judge Junior Division. So the initial dispute is the money lent by respondent number 1 to respondent number 5, which is only 50,000. So village council has no jurisdiction to entertain that application. And to prove this, my lord, I filed an application before the this local administration department. My RTI, it's online RTI application, my lord. It's in page 17.
Yes.
17.
Yes. RTI.
Yes, my lord. Page 17. May I read out again, my lord? What is the prevailing law used in village council area within Mizoram for the administration and setup of the village council? The answer is in page 18, my lord. The answer is the Lusai Hill District Village Councils Act 1953. Again, come to the question, my lord. Question number 2, page 17.
Whether the village council court.
Yes, my lord.
There is no provision under village council.
Yes, there is no provision in the village council, my lord. The question is whether the village council has the jurisdiction to resolve and settle disputes concerning property disputes or money disputes or disputes relating to money to property mortgage dispute. If yes, kindly state the specific act, chapter and clause for the same. The answer is there is no provision under the village council act. So since when there is no provision and when they don't have any power, my lord, I don't think the manage and the mutation is valid in law, my lord. The Lusai Hill District Village Council Act, I also put it in page 19. I don't find any powers where they can settle the disputes, money disputes, my lord. The act is there from page 19, my lord.
Powers and duties is given also, 8A.
But the money disputes cannot be resolved, my lord. No power to resolve the things there in the act, my lord. Because the Mizoram Civil Courts Act clearly specified that if it is below 2 lakhs, it has to be
It
before the
has
civil
to
judge.
be the civil judge junior division.
Yes, my lord.
Okay. Next.
Next, my lord, if I may take my lord to page 44 of my document, my lord.
44.
44, my lord. It's a judgment, my lord. P.B. Moidin Seva Mandir and another versus M. Kuti Hassan, my lord. The relevant part is in paragraph number 8, my lord, page 48. 47, my lord, sorry. I may read from page, paragraph number 7, my lord.
Para 7.
7, yes. Page 47.
Yes.
May I read on, my lord? It is unfortunate that the learned members of the Lok Adalat and the learned single judge totally lost sight of the purpose and scope of Lok Adalat. We may conveniently recall that what this court has said about the scope of Lok Adalat after referring to the relevant provision of the Legal Services Authority Act 1987 in state of Punjab in Jalar Singh. It is evident from the said provisions that the Lok Adalats have no adjudicatory or judicial functions. their functions relate clearly to conciliation. A Lok Adalat determines a reference on the basis of a compromise or settlement between the parties at its instance and put its seal of confirmation by making an award in terms of the compromise or settlement. When the Lok Adalat is not able to arrive at a settlement or compromise, no award is made in the case record is returned to the court from which the reference was received, though in fact it's not a reference here in our case, for disposal in accordance with law. No Lok Adalat has the power to hear parties to adjudicate cases as a court does. It discusses the subject matter with the parties and persuades them to arrive at a just settlement. In their conciliatory role, the Lok Adalats are guided by principles of justice, equity, and fair play. When the Legal Services Authorities Act refers to determination by the Lok Adalat and award by the Lok Adalat, the same act does not contemplate nor require any adjudicatory judicial determination, but a non-adjudicatory determination based on a compromise or settlement arrived at by the parties with guidance and assistance from the Lok Adalat. The award of the Lok Adalat does not mean any independent verdict or opinion arrived at by any decision-making process. The making of the award is merely an administrative act incorporating the terms of settlement or compromise agreed by parties in the presence of the Lok Adalat in the form of an executable order under the signature and seal of the Lok Adalat. Again, para number 8, my lord. When a case is referred to the Lok Adalat for settlement, two courses are open to it. A, if a compromise or settlement is arrived at between the parties to make an award, incorporating such compromise or settlement, which when signed by the parties and countersigned by the members of the Lok Adalat, has the force of a decree. May I stop here, my lord? According to my interpretation, my lord, it has to be signed by all the parties, my lord, not by a representative, my lord. Here in our case, actually, the one party did not sign the Lok Adalat award, and the signatory, the person who signed on behalf of the person is a beneficiary of the Lok Adalat award, my lord. Here, again, if I may just read out again, my lord. Para number 8, my lord. When a case is referred to the Lok Adalat for settlement, two courses are open to it. Number A, if a compromise or settlement is arrived at between the parties to make an award, incorporating such compromise or settlement, here in bracket, which when signed by the parties, it has to be first signed by the parties, my lord, and countersigned by the members of the Lok Adalat, has the force of a decree. According to my understanding, my lord, parties has to first sign and the members of the Lok Adalat has to countersign it, and then it becomes an award. Here in our case, actually all the parties did not sign the award, my lord. Someone has signed on behalf without having any authority, my lord. Number B, my lord, if there is no compromise or settlement to return the court to the failure report to the court, there can be no third hybrid order by the Lok Adalat containing directions to the parties by way of final decision, with a further direction to the parties to settle the case in terms of such directions. In fact, there cannot be an award when there is no settlement. Here in our cases, compromise was not there, but still an award was passed, my lord. My argument, my lord. In fact, there cannot be an award when there is no settlement, nor can there be any directions by the Lok Adalat determining the rights, obligations, title of parties. When there is no settlement, the settlement should precede the award and not vice versa. Settlement has first to be there and later award, my lord, according to my understanding, my lord. Number 9, my lord. When the Lok Adalat reports the minutes of a proceeding referring to certain terms and directs the parties to do a compromise deed or a memorandum of settlement and file it before the court, it means that there is no final or concluded settlement and the Lok Adalat is only making tentative suggestions for settlement. And such a proceeding recorded by the Lok Adalat, even if it is termed as an award, is not an award of the Lok Adalat. From this para, my lord, according to my understanding, even some award may be termed as an award. Sometimes it's not an award, my lord. Number 10, my lord. Although the members of the Lok Adalat have been doing a commendable job, sometimes they tend to act as judges, forgetting that while functioning as members of Lok Adalats, they are only statutory conciliators and having no judicial role. any overbearing attitude on their part or any attempt by them to pressurize or force parties to settle matters before the Lok Adalat by implying that if the litigant does not agree for settlement before the Lok Adalat, his case will be prejudiced when heard in court. Will bring this repute to the Lok Adalat as an alternative dispute resolution process, and will also tend to bring down the trust and confidence of the public in the judiciary.
Okay, have you given the para numbers in these judgments which you are relying on? The relevant paras?
I don't understand, my lord.
Have you marked the relevant paras in these judgments which you are
I don't
relying?
mark in court copy, I mark in my copy, my lord.
Can you just give the relevant paras to be relied upon so that I can read it? I can read it later. You try to come to a conclusion now. Now you're relying on those to say that this is a award which has to be interfered. Yes.
If I may just conclude my argument, my lord, before marking, my lord.
Okay. No, you keep it there. Keep it there. Yes.
My lord, what I'm trying to say is,
Yes. I have understood.
The Supreme Court directed NASA to form a uniform regulation with regard to Lok Adalat. And maybe because of this judgment, there's a National Legal Services Authority, Lok Adalat Regulation 2009. Here is very important, my lord.
No. This court also is aware because we have also been in the Lok Adalat. We have been mediators.
And here, my lord,
We
if I may just read
have
out
been
again,
presiding officer in the Lok Adalat also.
17 of the regulation, my lord, rule number 17 of the regulation. May I read out again?
Yes.
Drawing up of the award is merely an administrative act by incorporating the terms of settlement or compromise agreed by parties under the guidance and assistance from the Lok Adalat. When both parties sign or affix their thumb impression and the members of the Lok Adalat countersign, it becomes an award. As I repeat, keep saying, my lord, it's not signed by the parties. So even if it is countersigned by the members of the Lok Adalat, it cannot be termed as an award, my lord. In our case, my lord. And rule number 17, my lord. Point number 5. Members of the Lok Adalat shall ensure that the parties affix their signatures only after fully understanding the terms of settlement arrived at and recorded. The members of the Lok Adalat shall also satisfy themselves about the following before affixing the signatures. Very relevant, my lord. Point number 5A. That the terms of the settlement are not unreasonable or illegal or one-sided. Here in the award, my lord, it was recorded as if I demanded 4,50,000 from the respondent number 5, which in fact I did not demand. Which that 50,000 was carried by respondent number 5 at the time of Lok Adalat. Knowing that the respondent number 5 carries the 50,000, they report as if I demanded 4,50,000 from respondent number 5. And respondent number 5 gave me the 50,000 and 4 lakhs. It was just recorded as if that it shall be handed over by respondent number 5 to me, my lord.
Srimati Saran demands 4,50,000.
I did not demand, my lord. Actually, petitioner and respondent number 5 were together, going together at the time of Lok Adalat. And I was fully aware that 50,000 was there in our pocket. Because that 50,000 was carried by respondent number 5 as advised by one of the advocates who is to be the conciliators, saying that if the principal amount is only 50,000, Lok Adalat cannot get interest. So I was fully aware that she carries that 50,000. And in the award, reading the award, my lord, it was not recorded that respondent number 5 even agrees my demand. If whatever amount I demanded was to be given, I want to demand another much more, my lord. How come 4,50,000 comes in the award, my lord? If I just read out again the relevant part. Srimati Lal Sanjoli demands 4,50,000 from respondent number 5. As she has sold the land, today on this the 13/8/2022, she pays 50,000 forthwith. The total balance shall be repaid monthly. it has to be repaid monthly on what amount, my lord. It was not recorded. It's very one-sided, my lord. My lord, again, if I may take my lord through the affidavit in opposition filed by respondent 1 to 4, my lord. It's not paginated, my lord, but
Respondent number 3 and 4.
yes, my lord, 3 and 4. Though, it's 18, sorry, it's page 18, my lord. 11.2 last line, my lord. Page 18.
11.4.
11.2, my lord. Page number 18, 11.2 of the last line, my lord.
Yes.
At this juncture, the Lok Adalat has, upon recognizing the supremacy of law, came to draw a conclusion which was made with free consent and conscious deliberation of the parties, that the said land presently owned by respondent number 1, which was lawfully acquired by him from respondent number 5, be mutated in the name of so-and-so. And here in the bracket it says that respondent number 3 bought the said land on 22nd July 2022. In fact, the land was already sold by respondent number 1 to respondent number 3 prior to the Lok Adalat award. And as I submit in my earlier submission, my lord, according to my knowledge, the land was sold for an amount of 3 lakhs. So when the respondent number 5 carries only 50,000, they cannot take that money.
So you have not taken that money also?
I was forced to take that money, my lord. And that and my lord, on 13/8/2018, that land was never in my name. Why is the need to give me 10,000 each if that is not in my name? Kindly see again, my lord. Last line of the second para, my lord. Page number 4 of my application, my lord.
Yes.
To settle this Rohlua Kanan and Laltan Pua in order to, why do I need to be held, my lord, if that is not in my name? In order to help, the petitioner shall hand 10,000 each within August 2022. It was never handed to me. And apart from this, Zonun Sangi, daughter of petitioner, shall continue to stay in the house where she presently stays. Some directory order was there, passed against my daughter, who was not a party in the Lok Adalat, my lord. Until date, since she was not a party in the Lok Adalat, actually it's not been complied. I was there, the daughter of the petitioner is still now in possession of the one building, my lord. And when the initial money borrowed is only 50,000, how come it comes to 4,50,000, my lord? On what calculation, on what base, my lord? Actually, at the time of Lok Adalat sitting, my lord,
This is, I think, supposed to be the cost of the land.
But my lord, if the initial money is only at 50,000, how come it comes to 4,50,000, my lord? My lord, at the time of Lok Adalat, since the land is already mutated in the name of respondent number 1, I was advised by the conciliator sitting therein that I don't have any say in the property. So I was directed to demand money from the respondent number 5, wherein I never demanded. Till date, actually, I don't want this 4,50,000, I want my land back, that's all. And in fact, I'm challenging this award because I need to challenge that mutation. The Lok Adalat award bars me from challenging that award, my lord. challenging the mutation done by VC Pass, illegally mutated by VC Pass, having no jurisdiction at all.
Actually, there are so many disputed facts. How can the Lok Adalat pass such an award?
My lord, if I may.
Yes.
Firstly, I know that regarding the VC...
The Lok Adalat is even given directions. Yes. Lok Adalat cannot give directions.
My lord, it is a well-known fact that the VC court is in the power to issue a land to any person if they feel that it's needed.
VC pass.
Yeah.
That VC pass.
Yes. Till date, it has been done. And then it might not be there. Specific cancellation and all these authorities may not be there, but it is a well-known fact and practice that has been practiced till date. Because once it is given, they have also the power to cancel it. It has been done many times. So, excuse me. Okay. So, with regard to the authority of the VC,
no, that is a different thing.
Yeah, that's a different
we
thing.
are on the Lok Adalat.
Yes. And with regarding to the, if I think my fellow counsel has misled the court when it comes to the facts, because he has stated all the facts which has been, very irrelevant. The thing is that the petitioner has consented in mortgaging the land, which was actually given to, she has consented to respondent number 5, so that respondent number 5 would mortgage the land in order to get the 5,000 rupees.
50,000.
50,000 rupees, sorry. And at this point of time, they have gone to the village council court, because during that time, even the village council court has issued the land, which is within their jurisdiction. And so if there is a problem regarding that, it is the village council court that they had to approach at that point of time. And then they have approached that, and then it was twice that even the petitioner herself had relinquished her right over the land, saying that if the respondent number 5 cannot repay the amount of 50,000 to the respondent number 1, then I will relinquish my right. She does that. And then that is why the village council court said that, okay, if that is the case, we cancel it, mutate it to the name of the respondent number 1. It is clearly written. In fact, he had put it in his petition also.
That we have seen, the village council has mutated the land in the name of the respondent 1.
Yes. And regarding that...
so that's why I asked the petitioner why he didn't challenge that.
Yes,
that
actually,
village council
and at the same time, my lord, see, what we have to understand is that even the
no, but that was 2019.
Yes.
And Lok Adalat is 2022.
Yes. Before approaching actually they were not aware that Lok Adalat has to be first challenged.
No, my lord, it was...
What I mean is, before passing the Lok Adalat award, you had 2 years.
Yes.
That's during COVID time, my lord.
2 years
during COVID time,
that's
my lord.
an ample amount of time.
My lord, kindly see the year it was during COVID time.
2019.
It was 2020 March. And in fact, the borrowing money was already in 2018, my lord. And then a considerable amount of time was already given.
Borrowing, that is
2018.
But I'm talking about the mutation by the village council.
And that is before
that was done in
22nd June 2019.
2019.
Yes.
2019, yes. And then the award came only after 2022.
Soon after the mutation.
So by the time the award was passed, the property was no longer in your name. In your name.
Yes. So it's a clear fact, my lord. And at the same time, we have to consider the award also. And then during this time, even the presiding, my lord, even the judicial officer also was present, Mr. Thomas. He is also a judicial member. And then he should know, he knows, he is well aware of the fact of what had been done and what has to be done. He is not some random person. And then in fact, it is a very clear documented fact that the award itself here, it says that she actually was the one who dictated the terms of the award. If you can read it again, my lord. The award itself says, see the last paragraph. Sri Niti Lelsangzwali, who is the petitioner, demands 4,50,000 from respondent number 5 as she had sold her land today on this 13/8/2022. She pays 15,000 rupees with the balance 40,000 shall be repaid
balance 4 lakhs.
Yes. And she has also consented to the terms. There's no coercion. She's adult. And at the same time, it was not conducted in English. It was conducted in Mizo. She is well aware of the fact what was to happen.
So this 50,000 was paid on that
50,000,
day.
She took it.
And then what about the balance 4
The
lakhs?
balance has not been paid because it has been pending here. And then if I am not mistaken, I think the last judge has stayed the order also, my lord.
Oh, okay.
Yes. That is why we cannot proceed with, even the respondent number 5 cannot proceed with repayment of the remaining amount. So it is actually clear that, my lord, she was not forced. No coercion was made, no nothing was there. She was actually aware of the fact what would happen, and she took the money, consented to it, signed it. So there is no fault on her part, my lord, and no fault on the part of the Lok Adalat.
See, if on the day of the award, the property had been in your name, if the property had been with you, then it would have been different. But as on 13/8/2022, that mutation was already done long time back in 2019.
But my lord,
so this, it was no longer in your name.
Yes.
But
the
my lord,
property.
even if it was no longer in my name, why is my presence required, and what is the need for them to give me 10,000 each?
Because she demands it, my lord. It is really clear. She stated her problems, her needs and all that. That is why the petitioners, the defendants, the respondents have also felt bad for her, felt pity for her. That is why they actually wanted to help her. At the same time, they also asked the petitioner also that the daughters, they can stay till this and that date, so and so, and then, they can collect even the rent till the specified
December
date.
2023,
Yes,
still August
time.
2023. Then you take that 4 lakhs, you were saying that the land was sold for 3 lakhs. So you'll get 4 lakhs.
Yes.
Don't want that money, my lord.
My lord, that is the reason. If someone makes a decision today in front of the Lok Adalat and tomorrow she says, I cannot do this, then what's the point of having a Lok Adalat?
Because the Lok Adalat was not on my consent, my lord. My lord, if I may just
It is not consented. She's adult, my lord. She is adult who is actually well aware of the facts and the circumstances of the case.
Records, I think records are there, no? Lok Adalat records are also here.
And supposing it was conducted in English, I can understand, my lord. It was conducted in Mizo. she is actually, she knows it.
My Lord, if I may just read out the 1-2 judgment, my Lord, which are relevant for my case, my Lord. May I, my Lord?
No, the general principles
Yes.
by which the writ court can interfere in Lok Adalat, that is well known to this
my Lord,
court.
Very limited,
this
my
part
Lord.
is relevant because
Only if there
the
is
VC
fraud,
pass has passed the
coercion, and
the
force.
VC
my
pass
Lord.
has mutated the VC.
But the Lok Adalat has not said anything about mutation,
Yes.
about transfer of property,
But
nothing.
the Lok Adalat, the word, my Lord, affirms the mutation, my Lord, indirectly.
Whatever it is, our word has been passed, my Lord. So if we are to sit, if there's no coercion, my Lord.
If you want
No
to
fraud.
challenge the mutation, you can challenge.
But my Lord, the mutation, the Lok Adalat, the word bars me, my Lord.
No, it doesn't bar you. It doesn't bar you because nothing is said about the mutation.
It's there, my Lord, in the Lok Adalat. Here in the first line, my Lord, there, my Lord. May I read out again the Lok Adalat?
No, but it has not decided,
yes.
adjudicated anything.
No.
My Lord,
It is
if I may,
agreed,
my
it
Lord.
is agreed that house site such and such presently owned by Sri Lal Rolwa.
Yes.
See,
It affirms the ownership of
it is
respondent, my
agreed,
Lord.
it is agreed.
It affirms, no, my Lord.
Not affirm.
If this award is not set aside,
Not-
I cannot challenge, my Lord.
No, you can challenge. This cannot be a bar. Nothing is said about, it has not decided anything on the property, on the ownership.
Ownership of the property is there, it's written in the Lok Adalat, my Lord. It affirms the ownership of respondent number 1.
How it is affirmed?
How it
Where?
affirms, because it is agreed that house site number so which is presently owned by Lal Rolwa,
So,
being mutated in the name of.
so you have all agreed that it is now in his name. So that's why that is the Lok Adalat is just
Not only
saying.
that, my Lord, the mutation again, further mutation. It's written here, my Lord.
My Lord, it is not.
It is agreed
Not only the
that
ownership of
house
the
such and
respondent,
such.
but further
which is
mutation
being-
again here, it's written,
It is
my Lord.
agreed that house number such and such which is presently owned by.
My Lord, it is
Be
very clear.
mutated.
Being mutated in the name of C. Lal Kuya. See, my Lord, the further mutation is there written here, no, my Lord. If it's just the ownership of respondent number 1, well and fine, my Lord, I can challenge. But further mutation, if further mutation is allowed, how will I be able to challenge, my Lord? Somehow this what bars me from challenging, my Lord, the mutation.
It is agreed that house number such and such which is presently owned by.
It is not written, my Lord. It is
in the
simply
name.
stating that here, owned by Sri Lal Rolwa.
If this honorable court affirms the award, my Lord, I am barred from challenging, my Lord.
Because we want to mutate it, that is why. It is not written whether it is mutated or not. It is still in the name of Lal Rolwa. And at the same time, with regard to that, if it is already in the name of Lal Rolwa, then if he allows it, it's his property now. If
My
he
Lord,
allows
if this
it,
award
then-
is set aside by this honorable court, my learned friend don't have anything to lose. Because I will contest the mutation and well and fine.
My Lord, it is only the challenging of the word of Lok Adalat. So please, the court
No,
allows it, consider it.
We can clarify, we'll clarify that the court, the Lok Adalat could not have said that it should be mutated. Only that
No,
part.
further mutation is
Only
there.
that
That's why I'm
part.
challenging, my Lord.
Only that,
If only the ownership of respondent number 1 is written, it's okay. I can challenge, but further mutation is allowed by Lok Adalat, my Lord.
Even the orders itself says, my Lord, even in the order, it is already written that after a considerable length of time.
No, but you have to be very fair.
Yes,
See,
my Lord.
the Lok Adalat, they cannot say that this one should be mutated into this, that direction cannot be given.
And they have not given that, my Lord.
And
Lok
my Lord-
Adalat, yes, it was already in the name of Lal Rolwa. The Lok Adalat doesn't say anything about mutation. If it
No.
doesn't
No.
says
The
about
Lok
mutation.
Adalat has said, Lok Adalat says that it should be mutated in the name of Sri Lal Tanpuya.
Yes.
See.
Kindly read the award, my Lord.
No,
So
my
that
Lord,
part, the Lok Adalat could not have said.
My lord, if my learned friend can submit a sale deed in this regard, my lord, it will be quite clear, because it's already been sold by respondent number 1. Though they admit that it's already been sold, but they don't submit that sale deed, my lord.
Please, Your Lordship. Your Lordship, if I may further
Yes.
my co-counsel submission. Your Lordship, if Your Lordship may kindly look into counter affidavit at Annexure 7A.
1 minute.
The Lok Adalat Award, my lord.
Counter affidavit.
At Annexure 7A,
Annexure 7A, page.
page 52, my lord.
Yes.
If Your Lordship permits, I may read out the second para. Today, on this 13/8/2022, the petitioner Van Rohili of Vivacon and opposition party so-and-so are present. It is agreed, my lord, in respect of giving direction by the Lok Adalat, my lord, if Your Lordship look into that very language, it states it does not give any direction. What had stated herein is, it is agreed. Since the Lok Adalat is what is made based on an agreement, and here the Lok Adalat does not give any direction, it does not give any adjudication, it does not give any direction, but it clearly stated that it was agreed, my lord. So, based on agreement, it just simply passed the order. So, here at this stage, my lord, the thing is that though the petitioner counsel has submitted so many history regarding this, the fact of the case which is lead, but there is no need of it. If Your Lordship look into the order dated 1st February 2025 of this Honorable Court, on 1st February 2025, this Honorable Court has called for the record of the Lok Adalat Award, the Lok Adalat case.
Well, records are here, but
Yes.
there's
So,
nothing
records
here.
are here.
It just
Wait.
shows presence,
Yes.
presence of the parties.
Yes, my lord. Records are before this Honorable Court. Why? Because to show that whether or not the Lok Adalat Award was passed under coercion or not. The power of this Honorable Court is limited only to 3 conditions.
Yes.
3 ingredients must be there. 1, it must be passed under coercion. But it was not passed under coercion. If my lord perused the Lok Adalat Award, it can be seen that the whole of the award has been dictated by the petitioner herself, and the same agreed by her and signed by her. And secondly, my lord, it was passed under misrepresentation. It was not passed under misrepresentation. In whole of the petition, there is no allegation of the misrepresentation. And thirdly, my lord, fraud. There is no fraud in it, because the very content itself, if my lord peruse, it can clearly be seen that the petitioner herself is the one who dictated the terms and conditions, and the same is agreed. So, my lord, if I may take Your Lordship into Section 13 of the Indian Contract Act, consent, my lord, if I may read. 2 or more persons are said to consent when they agree upon the same thing in the same sense. This is termed as a consent, and the same is allowed. And again, my lord, what is free consent? Under Section 14 of the Indian Contract Act, it is clearly stated that free consent is said to be free when it is not caused by coercion, as defined under Section 15. And if we look into Section 15, my lord, Section 15 says that coercion is the committing or threatening to commit or any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property or the prejudice of any person whatsoever, and whatever with the intention of causing any person to enter into an agreement. So, my lord, looking to this, by perusing of this definition that has been provided under the Indian Contract Act, there is no coercion. Mere perusal of the word itself so that there is no such coercion or fraud in it. So, being in the absence of such ingredients which give the powers of this honorable court to...
No, from the very beginning, I told the petitioner that her signature is also there.
Yes, exactly, my lord.
And the party who did not sign, they are not aggrieved. They have not come before the court.
Exactly, my
saying
lord.
that their signature is not there.
Moreover, their father and son, my lord.
In respect of this, my lord, if that challenge must be made by the parties who does not have signed his signature, but luckily he is the father of the respondent number 4, so based on the authorities given by his father, he signed it. So there is no problem from our side. So there is no ground to challenge it, that matter. And so, my lord, in the absence of such ingredients which give this honorable court power to exercise its power under Article 226, the Honorable Supreme Court has held in the case Srinivasapa and others versus Malama and others in civil appeal number 3486 of 2022, my lord, it held. The emphasis has been already supplied in before you, my lord, in the previous day. So, if I'm... Yes, my lord. If I may kindly read out, my lord, a writ petition would be maintainable against an award of the Lok Adalat, especially when such writ petition has been filed alleging fraud in a manner obtaining the award of compromise. A writ court cannot, in a casual manner, set aside the order of the Lok Adalat. The award of a Lok Adalat cannot be reversed or set aside without setting aside the facts recorded in such a word as being fraudulently arrived. My lords, and then again, if we look into the Lok Adalat word, there is no fraudulent in it. The petitioner herself dictated the terms and condition, and later on she appended her signature. And my lord, we have termed this as the post-settlement dissatisfaction, my lord. If this post-settlement dissatisfaction, my lord, has been allowed, if this post-settlement has been entertained by this honorable court, it would have tremendous and adverse effect upon the sanctity of the Lok Adalat itself. Because all the agreements, all the words are only passed when the parties attain the agreement. So, if the petitioner who is a consenting age, if she is not dissatisfied how she dictated, it raised doubt. And again, my lord, if she again is not satisfied with the terms and conditions that has been dictated by her, why she appended her signature? All has been done by her. So, my lord, there is nothing which requires the involvement, the interference of this honorable court, and let this writ petition, with being without merit, be dismissed and read, my lord.
Okay.
With this, I read my submission.
Yes.
If I may just submit 2-3 points, my lord.
What more?
Here, my lord, I submit one judgment which says that the purpose of referring the matter to Lok Adalat is to negotiate the matter with the parties and to settle the case amicably by consent of both the parties. If any one of the parties are not present before the Adalat, conciliators in the Adalat cannot dispose of the matter.
But you were present?
All parties are not present, my lord.
The representative was present?
I represented. No letter of representation was there, my lord. He is, in fact, the most beneficiary person of the Lok Adalat award.
But they are not aggrieved. They are not aggrieved.
Okay, then, my lord. Here again, another judgment, my lord. Division bench of Andhra Pradesh High Court judgment, my lord. Here it says against, it has to apply its mind to the facts and circumstances of the case and the legal implications involved in the litigation to see that the legal rights of the parties are not jeopardized. Actually, in fact, the award jeopardized my legal rights. I cannot challenge, my lord. While passing a word as per the settlement arrived by the parties, it should also ensure that all parties whose presence is essential to resolve the controversy involved in the list are present before it at the time of determining any reference made with arrive as or a compromise settlement. My lord, just to submission, my lord. With regard to the this defect of jurisdiction of the BC court, my lord. It is a fundamental principle well established.
No, don't submit on the VC court because we are now only on the Lok Adalat.
My lord, why I am submitting? Because it's already dictated in the name of respondent number 1.
So that is a different thing. You challenge it.
May I just read,
yes.
my lord?
Yes.
It is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity and that its validity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution, even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary or territorial or whether it is in respect of the subject matter of the action, strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of the parties. It was alleged by the Counsel for Respondent 1 and 4 that a word was passed on my consent, the VC pass mutation was done on my consent. So here it says that a defect of jurisdiction, defect of VC court jurisdiction, my lord, whether it is pecuniary or territorial or whether it is in respect of the subject matter of the
You are
action.
again on the VC court. Okay. Heard learned counsel, such and such for the petition.
If I may, my lord, I'm appearing on behalf of respondent number 5.
Okay. Respondent 5, yes. What do you have to say?
My lord, actually, I am the one who borrowed money
Borrowed
from
the money, huh?
yes, from respondent number 1.
Yes.
By mortgaging a plot of land of the petitioner. And while for going to the Lok Adalat, me and the petitioner went together in the Lok Adalat for sitting. While we were there, I'm the one who carried 50,000. While we are going to the Lok Adalat sitting also, we can have a settlement outside the Lok Adalat sitting also. Why at the time when we reach the Lok Adalat settlement sitting, I am being forced to give the 50,000 to the respondent number 1,
To the
petitioner. So without having the Lok Adalat sitting also, we can have a good settlement outside the settlement also, outside the sitting area also. Why I am being forced to give 50,000 to the respondent? And at the time of hearing to the Lok Adalat sitting also, I was not giving a chance to clarify myself how this and that was happened during the taking of 50,000 rupees. And also that at the time when we tried to clarify, the learned member who was sitting in the Lok Adalat also, they said that settlement was already made and nothing has to be heard again. So everything was put in the award as they like. So even though in the sitting conciliator also, the judicial officer was present, and he must know very well all parties have to be present and they have to sign everything, each and everything, what have content, everything. But here in the award also, all parties are not present. Because here in the award itself, clearly says that there is some coercion. Because even for me also, if I have to pay the amount of 4 lakhs also,
4 lakhs 50.
yes, shall be repaid monthly only. Monthly. How, when, how long? Nothing was here in the award. For me also, how am I going to repay this one also? This shows that free consent was not here in this award. If there was a consent, if there was a free consent, let's say, even me also, I was supposed to ask the time and how long am I going to take to repay these 4 lakhs also. This clearly shows that I was not given any chance to clarify myself. Because see, my lord, I am just a hawker sitting in the roadside selling vegetables and also having a disabled son, because I was in dire need of money during COVID and also. That is why I approached the petitioner to charge it for 50,000, because maintaining disabled son is very difficult for me also. That is why I was trying to clarify myself at the time of Lok Adalat sitting also. I was not given any chance to clarify myself. I was not happy on this award. Quite, I am the borrower of this 50,000 rupees, but I was not given any chance.
You had borrowed from R5 actually,
Yes.
not from the petitioner.
No.
C is for respondent number 5.
Oh,
I'm
okay,
from
okay,
the-
okay. You had borrowed from
Yes,
R1.
yes.
R1.
That is why, even though, my lord, I am the borrower right now, but I was not given an opportunity at least to hear what I was planning to clarify at the time of Lok Adalat sitting also.
You were the one who had submitted the application to the member secretary.
Yes, my lord.
Application and the award was totally opposite, my lord.
At least I am to be heard at the time of the Lok Adalat sitting also.
Okay.
That is why, my lord, this award should be set aside and to be reconsidered again.
Okay,
If
thanks.
not,
Yes. Heard learned counsel for the petitioner, Mr. Such and Such. Also heard Mr. Just their names.
Zoudin
Just
Puyat Namte.
for respondent number
5.
5, MS Such and Such for
Respondent number 1.
respondent number 1 to 4 and 1 to 4. Their names, two names for respondent number 1 to 4. This order reserved. And the other item? Yes, just say list item 29, no? Oh, sorry. On the consent of the councils for the parties, list the matter. Next. Okay, 1st of September. 1st of September.
My lord, may I submit this paper after?
Yes, you put your paras, mark it, and then submit it. You send this also?
Obliged, my lord.
Much obliged.